Street.
My Lords, good morning. I'd like to start, if I may, by reverting to 2 points from yesterday. And at the risk of a degree of repetition, I'd like to go back again to the Tribunal's findings.
Yep.
I am very conscious that pretty much anything else I say to your Lordships, I said in the skeleton, and you can go back to that. But this is an aspect that is not covered in the skeleton. And so it is important to try to do it justice in the oral submission. And on that basis, could we look at the findings as they're recorded by his Lordship in the judgment, which is in the court bundle at tab 5. And if we could start at page 64, paragraph 22. Now, that's a cross-reference to the evidence of Mr. Gordimoff and the Tribunal's findings in the award at paragraph 13 to 14. The evidence of Mr. Gordimoff about needing to keep a fairly continuous flow of cargoes, and the Tribunal's conclusion that on the figures in the contracts, you would need to keep the berth more or less fully occupied. And if you look at the figures in the contract, you can see that. It's 280,000 metric tons per month, plus or minus 15%, in consignments of 30 to 40,000 metric tons. If you just take the base of 280,000 metric tons, you need to ship about every 4 days. And with a loading rate of 12,000 metric tons per day, it takes a bit over 3 days to load a ship. So that's the basis for the finding which the judge mentions being paragraph 146, that you have a continual flow of vessels in the performance of this contract. And with 95% of the freight being payable within 5 days after loading, you will also have a fairly continual flow of payment. Now, it is quite right, as my Lord Justice Mayle said yesterday, that if you look at it in strictly legal terms, what you have is a succession of payments in arrears. As if you look at it on a cargo by cargo basis, strictly legal terms. But if you look at it in practical commercial terms, what you have when this contract is up and running is a continual flow of cargo operations and a continual flow of funds to pay for them. Now, back to the judgment. If we could drop down, please, to paragraph 26, that's the force majeure notice, reference to the sanctions. Then the first point which is put is that the Royal believe it will be a breach of sanctions for them to continue with performance. There's a reference to GL 12. Moore do not say we're going to completely abandon performance, because we say on the strength of GL 12 that we will carry on to complete the transportation of cargoes which have already been loaded. So there's that carve out. Then we come to the reference to the sanctions will prevent dollar payments. And that would refer to dollar payments falling due for vessels which have recently been loaded, or dollar payments notionally falling due in the future for vessels which have not yet been loaded. Now, I may have misunderstood it, but I detected a sense in some of Lord Justice Newey's comments when I reflected on them, that we had somehow said, you needn't bother tendering US dollar payments because we won't accept them. And we didn't say that. But that is not what this sentence says. This is not focusing on acceptance or rejection by us. It talks about prevention of payment. That is prevention coming from RTI. And there's no suggestion in anything in the award that the tribunal thought that we had said, if you tender US dollar payments, we will reject them. There's no hint of that. There's certainly no finding to that effect. All you have is the correspondence, and on a reading of the correspondence, we didn't say that. The focus is on the making of the payment by RTI, by the payor, not the receipt or acceptance by us. And one sees, if one then goes on to paragraph 27, that RTI's response to what we said about prevention of dollar payments was not to say, you are wrong. There is neither a legal nor a practical impediment to the making of dollar payments. We can and we will pay in dollars for the cargoes which have recently been loaded and for which payment will become due 5 days after loading. We can and we will continue to pay in dollars for the cargoes which you should be loading in the future because you're not entitled to invoke force majeure. They did not say that. What they said was that they could pay in euros instead. Now that, I would submit, is quite obviously a tacit recognition that they do have a difficulty in paying in dollars. Because they didn't have a difficulty in paying in dollars, they would just pay in dollars and say they were going to do it, and they didn't. Now we then get the response to that set out by the judge in paragraph 28, the response by Mur to the suggestion that payment should be made in euros instead. And that is what the judge called at paragraph 156 a common sense approach. That Mur could not be expected to maintain the continual flow of cargo operations in the absence of the corresponding flow of funds. There's then the analysis of the nitty-gritty of the US legislation, which I don't really think we need to look at, so I'm perhaps to jump over to page 67. And we then get paragraphs 44 and 45, which is the part where the tribunal move on from what is the strict legal analysis. They've decided that as a matter of strict sanctions legal analysis, it would not have been unlawful for RTI to make payment in dollars, or for US banks to process payments in dollars. It would have been lawful, but in practice, it wouldn't have been that straightforward for the reasons they set out here. And paragraph 45 of the award, which the judge quotes at paragraph 39 of the judgment, that is a paragraph which in the award, the judge doesn't reproduce it, but in the award, that is prefaced by the word crucially. And it is in my submission important to note that. Because what that shows is that the finding which the tribunal is making here is important to its reasoning and its conclusion. This is not some piece of contextual background. It's not an incidental finding along the way to the conclusion. It is a matter which is crucial. And paragraph 46, which the judge then sets out at the beginning of paragraph 40, ties in to the crucial finding, because the point that's being made, in my submission on a fair reading of the award, is that the issue which has been identified at paragraph 45 can't be got round by routing through a non-US bank, which won't be caught by sanctions because it's a non-US person. May not be concerned about the sanctions. You can't get round it by routing it through a non-US bank because dollar payments invariably are routed through US banks. So the issue identified at 45 cannot be made to go away. Then there's the finding at paragraph 50 that accepting payments in euros is a much more realistic possibility. Now, I do submit again, that alternative would not have been necessary if it was possible for RTI simply to comply with their contractual obligations and pay in dollars. The very fact that they were making that proposal to pay in another currency shows that they could not comply with their obligations in the right currency. Then one gets the ultimate finding by the tribunal at paragraph 51, and it is necessarily implicit in that the requirements of clauses 36.3a and B and C were, in the view of the tribunal, all satisfied, and everything hinged on 36.3d, which is why we're all here today. Now, the analysis is clearly compressed, and I said yesterday there will be reasons why that's so. But, as the judge said at paragraph 54, a court reading an arbitration award approaches it in a reasonable and commercial way, expecting, as will usually be the case, that there will be no substantial fault. Court reading an arbitration award does not approach it with a view to picking it apart and finding holes and defects in order to undermine it. And that is the famous dictum of Mr. Justice Bigham in Zermatt Holdings, which is frequently cited.
That's a submission which is usually made by those seeking to uphold an award.
Doesn't affect the validity of the statement, my lord, whether it be made one way or the other. It's a well-recognised principle and a thoroughly correct one in my submission, and routinely applied. Now, my lord, on adopting that approach, the reasonable and commercial reading is, as the judge said at paragraph 133, that in relation to the requirements of clause 36.3c, the tribunal concluded that the situation constituted either any rules or regulations of government or any interference or acts or directions of government.
Sorry, I've lost you. Where are you in
It's
the...
more restrictions on monetary transfer.
Or restrictions on monetary transfers and exchanges.
Because as if you pointed out, the finding was not that it was unlawful, but that in practice the payments would be held up.
Yes, indeed. But one might say it would be held up in response to a rule that had been issued by the government, and that was sufficient. But it's
more because of uncertainty.
It's more obviously monetary restrictions on monetary transfers and exchange, but it doesn't matter.
And just before you go any further on that, you gave a reference in the judgment, which I didn't pick up.
That's paragraph 133, my lord.
133.
And that is where Mr. Justice Jacobs, going through the process which your lordships have had in mind about what's the reasoning here, says, well, the fair reading is that was what the tribunal thought was the answer in relation to to clause 39.3c. What was the nature of the event in question? It was most probably monetary transfers and exchanges restrictions. And then, in relation to the requirements of clause 36.3b, the reasonable and commercial reading of the award is that the tribunal accepted Mur's common sense proposition, as the judge called it, that Mur could not be expected to maintain the continual flow of cargo operations without the corresponding continual flow of funds. And it was common ground before his lordship that that was the fair reading of the award, as the judge recorded at paragraph 134 and paragraph 149. And it is inherent in the tribunal's acceptance of the common sense proposition that the tribunal accepted and held that there was indeed some impediment to that continual flow of funds. And when one reads paragraph 51 in the award in the context of the crucial finding about the practical effects of the sanctions on US banks in paragraph 45, followed by paragraph 46, you read it in that context, the fair reading of the award is that the tribunal found that payments would at least be delayed by the banks, even if they would not necessarily be permanently prevented. And coming back again to what I detected Lord Justice Newey may have had in mind, there is simply nothing in the award to suggest that what the tribunal thought was that RTI could in fact at all times have performed their payment obligations by paying the right amount of money in the right currency at the right time.
Well, of course, it does depend to some extent on what you mean by that, because, of course, the whole point of this scenario is that RTI could have paid on time in the sense that they could have transmitted their payment on time, but it wouldn't have arrived on time through no fault of theirs because it would have been held up en route.
Well, the no fault of theirs might have been a reason why they might have wanted to invoke the force majeure clause, but they did.
But they didn't.
So the position was that they could pay the right currency but not at the right time. That's not contractual. Or the alternative, they could pay at the right time but not in the right currency, and that's what they offered to do, but that's not contractual either. So they could not contractually perform. That is that's the sense of the award. That's the fair reasoning. That's what leads to the conclusion in paragraph 51 of the award. Now, to the extent that the tribunal's findings are purely factual, they are immune from challenge. To the extent that the tribunal's findings raised any issue of law, RTI challenged them before his lordship on the question of causation, essentially on the basis that causation was not established because it was Mur's own decision to suspend performance in the light of the payment problems, and that meant that the problem was self-induced. And Justice Jacobs dealt with those arguments in detail and in full in paragraphs 132 to 170. And as summarised at paragraph 149, his essential conclusion was that that was at very best a mixed question of fact and law. It did not give rise to any principle of pure law. And there was no error of legal principle in the tribunal's approach. And the tribunal's decision was within the range of permissible conclusions. And therefore the challenge on causation and self-induced force majeure failed. And permission to appeal on that point was not given. So the tribunal's conclusions are not open to challenge on that basis either. And that, in my submission, is what the findings of the tribunal amount to. A different tribunal might have decided differently. A court looking at the award with the benefit of hindsight might think it might have been expressed better. But this is the process which the parties signed up to. These are the arbitrators they chose. That is their decision. It is not open to challenge. The second thing I wanted to come back to is my Lord Justice Mayall's question. Isn't the question about overcoming rather than reasonable endeavours? And having reflected on that, I would with respect say that the answer to that is no. Overcoming is not the question. It is a question. And a question very well taken by my lord, and perhaps we should have thought of it in those terms earlier. Because if the conclusion is that the proposed cause of action will not overcome, as required by 36.3d, then the course of action cannot be required under the reasonable endeavours proviso, regardless of whether it would require a lot of effort or no effort at all, because it will not lead to the relevant outcome. And as your lordships know, we do submit in the skeleton argument, paragraphs 26 to 31, that the concept of overcoming a force majeure event does mean overcoming the impediment to performance of the contract in accordance with its terms, such that performance of the contract according to its terms can be resumed. Overcoming is looking to restore the status quo. And we do submit...
Sorry, could you just give the skeleton reference?
My lord, yes. 26 to 31.
26, thank you.
We do submit that switching to euros instead of the contractual dollars in this case would not have overcome the impediment. It wouldn't have taken the sanctions away. And it wouldn't have taken away the effect of the sanctions in terms of preventing payment in the contractual currency. It wouldn't have allowed payment in dollars to resume. It would have abandoned payment in dollars. It would have moved to a different currency, a non-contractual currency, and it would have amounted to a variation for the duration of the force majeure event, acceptance of a non-contractual performance. It would not have overcome the impediment in the appropriate sense.
So you've just articulated cogently good reasons for answering my lord's question yes. So why do you answer it no?
The reason that I answer it no, my lord, is this. If the court is against me on that, and if the court says, no, switching the currency of payment would have overcome the problem in a commercially acceptable sense, and overcoming is not really particularly concerned with the performance which is required under the contract. If that was the court's view, I would nevertheless say that we were not required to switch and to change the contractual performance under clause 36.3d, because a reasonable endeavours proviso should not be taken to extend to giving up contractual rights, varying the non-contractual performance, unless it makes that intention clear, and this contract does not. Now that's the point. I don't want to go over it again. I went through that point yesterday.
Well, why does that not amount to a primary case and an alternative case?
It does.
So your primary case, on that way of looking at it, seems to be you don't overcome, but if you do, reasonable endeavours don't extend that
Your
far.
Lordship is entirely right. My only point of resistance to my Lord Justice Mayles is he says, is that the question?
Right.
And I say it's not the question.
It's not the only question.
It's not the only question. That's why I say it's a question, and a very good one.
Right.
But it's not the only one. My Lord. And on that point about we say that we're not required to do it unless the wording makes that clear. Again, coming back to a point of my Lord Justice Mayles, I would submit it doesn't matter that on the facts of this particular case, the proposed step would not have involved us to take, as Lord Justice Mayles said, any particular endeavours at all. It would just been accepting an offer. Because reasonableness does not come into it if we are right. It doesn't matter any more than it mattered in Bullman and Fenwick that the jury found that the charterers could and should reasonably have redirected the vessel, and that would have avoided the implications of the strike, and the vessel would have been discharged within the lay days. Now, Bullman and Fenwick is a commendably short report. It does, in my submission, repay some study. I have highlighted the parts which we particularly rely upon in the skeleton, paragraphs 41 to 47. And given the time, I won't go through those with your lordships. I do emphasise the finding of fact that I've just referred to. That's the one that Baron Pollock calls the jury's second finding of fact, that the charterers reasonably could and should have sent the vessel a few miles downstream to one of the other named locations. And if they'd done that, the vessel would have been discharged within the lay days, the strikes would have been avoided. Now, your lordships know from yesterday that that's finding of fact is at page 3 of the authorities bundle. My learned friend emphasises another finding of fact, which is on page 2 of the authorities bundle, that the charterers could not have, by due diligence, improved the situation. And what I submit in relation to that is, as Lord Justice Arnold said yesterday, when you read the findings of fact together in context, it's perfectly plain that the finding of fact at page 2 is that there was nothing the charterers could have done to improve the position at the Regent's Canal once the vessel had arrived at the Regent's Canal. That's the first finding of fact which appears to be made. And then one goes on a page, and his lordship, Baron Pollock, is asking the jury to make further findings of fact. And indeed, it's precisely because there was nothing which the charterers could do to improve the situation once the vessel arrived at the Regent's Canal, that the separate finding that they could and should have redirected the ship before it got there assumed such potential importance in the case. Because since redirecting the ship was the only thing which the charterers could have done to overcome the situation, that raised the legal question of whether it had been incumbent upon them to redirect the ship and to change the performance. And this is the way that Baron Pollock put it at the bottom of page 3 of the report. He says it raises the question whether the charterers were entitled to order the ship to Regent's Canal, quote, and leave that order undisturbed, although before she got there the strike commenced, unquote. And it's that leave the order undisturbed that was really the key issue. Because the owner said no. You have a situation here where the timing is set out in the report. Vessel is given orders to go to the Regent's Canal when it leaves the time. Nothing wrong with that at the time, no strike. Strike then breaks out a few hours after the vessel left the time. Owners find out about the strike the same day while the vessel's steaming down the east coast of the country. And the owners say, well, at that point, you should have redirected the vessel. And the jury say, we think, as a matter of fact, that you should, because that would have been a reasonable thing to do. And Baron Pollock says, well, those are the facts, what's the law?
It does seem to be a fact that it mattered to the charterers that they should have the cargo at the Regent's Canal.
Well, but
that's the finding of effect in the first full paragraph on page 4. They required the coal near Regent's Canal because that's where their customer was, and it was important to them that she should go there, as distinct from one of the other places. Now, you don't have that feature in this case, do you? Because there is a finding of no detriment if you get dollars in your account through the medium of converting from euros.
This is the point that we mentioned briefly yesterday. Yes, I take on board that there is that finding. Now, one does bear in mind that these locations are all on the Thames in London. We're not talking about sending the ship to Southampton instead of to London or anything like that. We're not talking about vast discrepancy. And one does have the finding of the jury that, notwithstanding that was the evidence because it's mentioned in the judgment, the finding of the jury was nevertheless, looking at it reasonably, they ought to have done it. So that was a factor to be taken into account in the reasonableness finding of fact. It didn't displace the jury's conclusion that it would have been reasonable to make the redirection, and it's at that point that the question of law arises. Now, we've got the equivalent here, the finding by the tribunal that it would have been reasonable for us to accept payment in dollars. Now, your Lordship's point may be, well, perhaps it would have been more reasonable in this case than that case. But you can't really approach it on the basis of slicing up degrees of reasonableness. You've got a clear finding by the jury in Bournemouth that it would have been reasonable. We've got a finding by the tribunal here that it would have been reasonable. And the question is, what's the legal significance? That's the point. and Baron Pollock, as one sees as he goes on the same page, says it's not a question of reasonableness. The answer to the question, did you have to redirect, isn't governed by the jury's finding. It's a question of what are you legally obliged or entitled to do under the contract. And he said, he concluded that there was a right under the contract to maintain the order after the strike broke out, and the effect of that was that charterers were entitled to rely on the strike clause, as he put it, quote unquote, notwithstanding the finding of the jury. That's at page 6. And in context, that's clearly a reference to the finding of the jury that they reasonably could and should have redirected. And when the case came up before the Court of Appeal agreed. Lord Esher, in the only judgment, said that nothing had happened, notwithstanding the outbreak of the strike when the ship was at sea, nothing had happened which made it incumbent upon the charterers to change their order. And that was notwithstanding the Court of Appeal's express acknowledgement that the charterers could not sit on their hands and they must use, quote unquote, reasonable exertions. But it wasn't within what was required of reasonable exertions that the charterers should change their orders and change the performance. Now, I highlight the reference to reasonable exertions because one of my Lord Justice Newey's points yesterday was, well, if Bullman is concerned with some sort of implied proviso, that it may not necessarily be in the same terms as an express proviso. But I would suggest, my Lord, that reasonable exertion sounds pretty similar to reasonable endeavours, which is what we've got here. And likewise here, in my submission, it was not within the reasonable endeavours which were required under 36.3d for Mur to accept payment in a non-contractual currency and change the performance. Now, my Lords, RTI make 7 points about Bullman and Fenwick, and we respond to them in our skeleton paragraphs 49 to 65. And again, given the time, I'm not going to go through them all. I would just like to highlight one of them because it chimes with a point made by my Lord Justice Newey yesterday. That's paragraph 40 of RTI Skeleton, where they say that the reason why the charterers in Bullman were required to exercise reasonable exertions was nothing to do with an implied proviso, it was just to do with causation. Now, first point I make about that's the point I made yesterday, therefore I won't go back over it, but I do submit that it's a false dichotomy, because ultimately a reasonable exertions proviso, whether express or implied, comes back to the causal question. Just another way of looking at causation. So it's just it's drawing a false distinction to say it was about causation, not about implied provisos. But secondly, if one were to accept that in principle there is some legitimate distinction between causation and implied provisos, Lord Esher does not express it in terms of causation. There's no reference to but-for cause, there's no reference to causation in any form. He simply says they could not sit on their hands, and if they could have overcome the problem by reasonable exertion, then they had to do so. It is couched in the terminology of an onus upon an affected party to exert themselves to overcome the impediment. And third, Bullman has not been received subsequently in terms of causation. Refer your lordships to some textbooks at paragraph 58 of our skeleton. I took the court to some of them yesterday. And they cite Bullman's authority that an affected party must exercise reasonable endeavours. Again, they don't put it in terms of causation. They don't talk about but-for cause. They don't talk about cause at all. Lewison in particular, paragraph 13.24, that's tab 13, page 744, I took the lordships to it yesterday, refers to it as a principle of interpretation. And he then goes on to quote, as I showed again your lordships yesterday, the judgments of Lord Justices Griffiths and Carr in B&S Contracts and Green. You've got that in tab 12, but as I say, Lewison sets out the quotes. And again, they don't put it in terms of causation, they refer to Bullman. Lord Justice Griffiths refers to it as relating to construction of the contract. And Lord Justice Carr called it a principle, which in my submission suggests a principle of construction, rather than some application of but-for causation. Now, my lord, that's Bullman. It's a very short case. We've given it quite a lengthy analysis in our skeleton. And then has the Vancouver strikes. It's a very long case. But it is possible, I think, to give it a rather shorter analysis for this reason. There's not really much dispute about what it decides in terms. The dispute between the parties is really more what, if anything, can the court deduce from it, which is relevant to this case. We've summarised the background in the skeleton argument at paragraph 66 and following. The first thing which the House of Lords decided in terms, and they were upholding the Court of Appeal, and the Court of Appeal were upholding Mr. Justice McNair. The first thing decided was that the contract in Vancouver strikes was not a Brightman v. Bungy and Vaughan type contract. It looked a bit like it, because it referred to 3 cargoes, wheat, barley and flour. The Brightman contract referred to 3 cargoes, wheat, maize and rice. The Court of Appeal in Brightman had held that the true construction of that charter party was that the charterers had to load wheat, or maize, or rye, or a combination of the 3. And if they wanted to load wheat but they couldn't get it, that didn't affect their contractual obligations, because they just had to get maize or rye instead. And therefore they could not rely upon a clause which said that there was an impediment to loading the cargo, because the cargo meant maize and or rye and or wheat. The House of Lords held that what they had before them in their case, in the true construction, was a charter party which was for wheat, but which gave the charterers an option to load barley and flour instead. But that was charterers' option, and unless and until they exercised it, it was a wheat contract. The second thing which the House of Lords held in Vancouver strikes was that if there was a strike which prevented the charterers from loading the wheat, they were not obliged to exercise their option and load barley or flour instead. So different outcome from right. Different contract, different effect, different obligation, different outcome when it came to the application of the exception. And the effect of that was that when a strike prevented the charterers from loading wheat, they were entitled to rely on an exception which applied if, quote unquote, the loading of the cargo is delayed by strikes, because the cargo was the wheat, unless and until the option was exercised. And their refusal to exercise the option to load wheat or flour instead did not deprive them of the benefit of the exception. As the head note puts it, and it's paraphrasing Viscount Radcliffe, they were not obliged to lose the protection of the exception by exercising their option. Now, as we set out in our skeleton at paragraph 81, Moore would submit that that's all of a piece with Bullman and Fenwick. And that's what the judge held at paragraph 102, and I would submit he was right. What you get in Vancouver strikes, very much like Bullman and Fenwick, you have a contract which expressly contemplates different methods of performance. The charterer selects one of the specified methods. It does that by not exercising its option, so that it remains a wheat contract. An event occurs, a strike, which is within the ambit of an exceptions clause. That event has a causal impact on the charterer's selected method of performance because it delays the loading of the wheat. So there is there, on the face of it, a prima facie right for the charterers to rely upon the exception. There is then an argument in response by the owners seeking to defeat that prima facie right, to say, no, what you have to do is to load one of the other cargoes, which is referred to in the charter party, and a decision of law by the first instance judge, the Court of Appeal and the House of Lords, that it was not incumbent upon the charterers to vary performance, and that their failure to do so did not deprive them of the protection of the exception. Moreover, since the charterers had the option to switch cargoes from wheat to barley or flour, the point which RTI make about Bullman and Fenwick in their skeleton at paragraph 45 does not apply. What paragraph 45 says is, oh, well, in Bullman and Fenwick, once the charterers had selected them, they weren't entitled to change it. Now, that's a bad argument for reasons which we've addressed in paragraph 60 of our skeleton, but it's not relevant in the context of Vancouver strikes because there was no doubt that the charterers had a right to switch the cargo, but they were entitled to exercise that right as they saw fit in their own interests. They were not obliged to exercise it for the benefit of the owners so that the loading of the cargo could be resumed. And we say the same here. We didn't have an express option to take payment in euros instead of dollars, but it was always open, of course, to agree to vary the contract. But unless and until we did that, we had a right to receive payment in dollars. And that was an unfettered choice on our part, in our submission, whether we were to give that right up and accept payment in euros instead. We were not bound to do so, pursuant to clause 36.
Just so we get the context properly, the clause relied on there was the clause 31 we see at the bottom, page 44 of the authority bundle.
My lord, yes, that's it. Exceptions from lay time clause. Time not to count.
Yes.
Now, my lord, there is not, as your lordship will see, an express reasonable endeavours or negligence proviso. And on the back of that, RTI's main point in response to Vancouver strikes, I think it's really their only point, which is set out in their skeleton at paragraphs 48 to 49, they say this: the only issue in the Vancouver strikes case was whether there had occurred in the first place an event which was capable of falling within the exceptions clause. That is to say, a strike which had had a causal impact upon the loading of wheat. To decide that, RTI say, it was necessary to decide whether it was a Brightman-style case or not, and that's why the House of Lords decided that point. But RTI would have the court think, no one in Vancouver strikes had in mind any kind of reasonable endeavours proviso. No one had in mind that even if it was not a Brightman case, and therefore there was no obligation to exercise the option as a matter of straight contract, as there was in Brighton, no one had in mind that it might nevertheless be incumbent upon the charterers to exercise the option as a result of a reasonable endeavours proviso. And so they say Vancouver strikes really has no bearing upon reasonable endeavours. And we submit that is wrong for all of the reasons which we have set out in paragraphs 83 to 92 of the skeleton. And I will not go through them, but I would just like to highlight one. And that is contrary to the implication in RTI's skeleton. Mr. Justice Rusal, QC, did not concede in the Court of Appeal that the question of reasonable endeavours was of no conceivable significance. The suggestion that he somehow sold the pass in the Court of Appeal and gave up a point that he might have prevailed upon if he'd only stuck with it. He did not. The comment in question is at tab 5 of the Authorities Bundle, page 131. And what Mr. Rusal QC said was, it is not a question of whether it is reasonable for the charter to switch. He is obliged to do so, and the only question is how long it is reasonable to take in obtaining alternative cargo. And that comment, if one looks at it in the context of the report of the argument, was made in the context of Mr. Rusal's argument that Vancouver Strikes Charter Party was like the Brightman and Bourne Charter Party, that it was a contract to load wheat and or barley and or flour, and if you couldn't get one, you had to load either or both of the other two. And the legal context was that part of the decision in Brightman was that although in a Brightman Charter Party, if you couldn't get the one cargo, you had to load either or both of the other two, you would be given a reasonable time in which to get hold of the alternative cargo. By the time Vancouver Strikes got to the House of Lords weren't entirely certain about that proposition, but Mr. Rusal wasn't to know that when he was arguing the case in the Court of Appeal. Indeed, in the Court of Appeal, it was settled law that if the charterers were obliged to switch, they would be given a reasonable time in which to do so. And what Mr. Rusal was saying was, if it was a Brightman case, and his argument was that it was a Brightman case, if it was a Brightman case, then charterers were not merely bound to exercise reasonable endeavours to switch cargoes, they were bound to do it. And the only significance of reasonableness was that they be given a reasonable time. He was not saying that he conceded that if it wasn't a Brightman case, the charterers did not even have to exercise reasonable endeavours to switch cargo. He was not making that concession. And as we point out in our skeleton at paragraph 92, when we get to the House of Lords, by which time Mr. Rusal has become Mr. Justice Rusal and Mr. Roche has stepped up. Mr. Roche says in terms, page 217, tab 6, if it is held that charterers are not bound to ship an alternative cargo, what he means by that, if it is held that it's not a Brightman case, then the test is whether the charterers acted reasonably, and on the fact of the present case, they did not. Now, it is right to say that he did not press that point very far. perhaps that's because he had little expectation that it was going to get much traction. But the point was there. And it is not correct either to say that there was simply no issue at all about reasonable endeavours in Vancouver strikes. And there are other passages which we submit show that reasonable endeavours was in play. We refer to those in the schedule. So Vancouver strikes cannot simply be sidelined on the basis that it's about an entirely different issue and has nothing to do with reasonable endeavours. And we submit that Mr. Justice Jacob is quite right at paragraph 102 that it is consistent with Bullman in indicating that it's the nature of the contractual right and obligation which determines the ambit or the limits of what can be required under a reasonable endeavours proviso, be it express or implicit, and not broad considerations of reasonableness in which everything is up for grabs and can be put into the mix and left to the judgment of the individual tribunal or judge. Incidentally, in relation to the question of authority, we do submit that there's nothing in this argument at paragraphs 29 to 30 of RTI's skeleton that his lordship took an unorthodox approach by starting out by saying there's no authority for RTI's proposition, rather than by deep diving into a wooden capita style analysis of the text of the contract. Your lordship will note that although there's some criticism of Mr. Justice Jacobs for starting out by saying there's no authority in RTI's favour, they don't say he's wrong. I understood to confess yesterday he's right. There is no authority. It's not really appropriate to suggest that his lordship should have begun by a granular analysis of the text, because they said to your lordship yesterday, the question issue is a general principle. You're not going to find the answer by a granular analysis of the particular wording of this particular clause. That's the narrow case which I'm coming on to, but the broad case is a question of much more general application than what does this particular contract say. And so it's misconceived to say that that's where the judge should start. And in any event, it doesn't matter which element of the multifactorial approach his lordship started with, whether with the case law, or looking at the text, or considering commercial considerations. It's rather like wooden capita, where Lord Hodge says, it doesn't matter where you start, as long as in the course of the iterative process you cover all of the bases. It didn't matter where Mr. Justice Jacob started, as long as he covered all the bases, and he did. It's not right to say, as RTI say at paragraph 32, that having considered the authorities, Mr. Justice Jacob somehow then stopped and didn't take into account questions of principle. He refers to...
I wonder whether it's worth spending more time on this aspect. Just thinking on, what you really have to deal with now is the other side's authorities, is it?
Yes, I'm going to come to those. Yes, I am going to come to those, my lord. Let me just give you finally a reference on that point, my lord. We set out paragraph 40 of our skeleton where Mr. Justice Jacobs referred to all the points of principle which we have repeated in asking.
I wonder whether it's worth spending time on that.
And he accepted it. Now, my lords, I want to deal briefly with the narrow case and then say something about the authorities cited against me. Now, the gist of the narrow case, it's set out at paragraph 24, I learned from skeleton, and it is this. Reasonable endeavours won't extend to variation or non-contractual performance in relation to cargo operations, but it can extend to variation or non-contractual performance in relation to any other aspect of performance of the contract, and in particular to payment rights and obligations. Now, my lord, this is the secondary case, as made clear by my learned friend Skeleton, so it only arises on the hypothesis that they've lost the primary case, and so the starting point would then be that we are right on the broad case, and that a reasonable endeavours proviso does not extend to variation or non-contractual performance, unless something in the wording of the particular clause indicates that it does. And so one is looking for something in clause 36 which shows that there is an intention to extend the effect of the clause in that way. and the judge sets the clause out at 62 to 63. One logically begins, I would submit, by trying to find some relevant wording in the reasonable endeavours clause itself, which is 36.3d. There is nothing there. The case is in fact based upon 36.3b. That is where the reference to loading and discharging is found. That does not look promising in my submission because on the face of it that's got nothing to do with reasonable endeavours at all. And in order to link B into D, RTI are driven to arguing that it at the beginning of D refers back specifically to the delay to loading of the cargo at the loading port, discharge of the cargo at the discharging port, and providing the proposed workaround will overcome that, then it has to be adopted if it's reasonable. And the problem with it, and in my submission, the insurmountable problem with it, is it just does not work as a matter of language. It is perfectly plain, as the judge said, that it, which is the opening word in A and B and C and D, it refers back to the force majeure event, which is a state of affairs, event or state of affairs which meets all of the following criteria. And then it's it. That's what it means. And contrary to what my learned friend sought to argue yesterday, I submit that Lord Justice Arnold was quite right. You can't get the argument off the ground without postulating that it in D means something different to it in A, B, and C. And it's simply not permissible by any process of construction. It's not an ICS case where you can say the parties have made a mistake and we can see what they meant to say. They said what they meant to say. It's a perfectly sensible definition. It's perfectly workable. And that's what it means. You can't shoehorn some different meaning into it. Apart from anything else, even if it might work linguistically, there's the judge's point. We dealt with this around paragraph 111. But it presupposes that the parties had in mind some hierarchy of ranking of clauses, in which you single out rights and obligations which relate to cargo operations. They can never be changed. Anything else is up for grabs. It's transparently self-serving because it gives primary importance to the provisions which are of most interest to the charterers. They may think that the contract is all about getting their cargoes transported from Conakry to Dneprobugsky. But from my client's point of view, the purpose of the contract is to earn some freight. And the payment obligations are very important. And that's what the judge said, and rightly. These are all important obligations. There's no sensible basis for thinking that the parties intended to give preferential treatment to one above the other. The other point which Mr. Justice Jacobs made, and I do want to say something about this before I come on to the authorities, he says, you look at the list of things which can constitute force majeure in terms of government interventions, strikes, war, bad weather, restriction on monetary transfers, and so forth and so on. Some of them may have a direct effect upon cargo operations. With some of them, it's very unlikely that they are going to actually physically interfere with the cargo operations and make the operations impossible. And that's particularly true for restrictions on monetary transfers. Want of money is not going to make it physically impossible to load or discharge cargo. The effect it's going to have is that someone who has to be involved in the process isn't going to get paid. Therefore, they won't do the work. So it will be an indirect effect. And Mr. Justice Jacobs says that you might get a situation, as happened here, where there's a sort of waterfall effect. There is an event occurs which has an impact upon one part of the contract, here payment in dollars. There's then a knock-on effect on the cargo operations which come within B. And there's no reason to think that if the parties were seeking to overcome the situation, they'd only be focusing upon the secondary number. They want to overcome the whole of the problem that have been caused, including the first one, which in this case is the restriction on payment. And I just wanted to say something about what is said by RTI about that in paragraph 60 of their schedule, where they make this point in the context of indirect causation and clause 36.3. They say this: recognising that impediments to loading and discharging have a special status in the FM clause by reason of clause 36.3b. It is difficult to think of any good reason why the party should be taken to have intended Mur to be entitled to declare force majeure when the proximate impediment to loading and discharge was their own, as the tribunal held, unreasonable refusal to accept payment in euros. Now that is very redolent, that proximate impediment, of the causation arguments which RTI put to the judge in the context of their argument that Mur was guilty of self-induced frustration. And indeed, if you look at the judge's summary of the arguments at paragraph 142, you can see that in that context they put the same point in almost exactly the same words. Now, our broad answer before Mr. Justice Jacobs to all of these arguments about indirect causation was that if the clause can apply to indirect causation, and it clearly can, then it applies when Mur's own conduct comes into the chain of events, unless Mur's own conduct amounts to a break in the chain of causation or novus actus interveniens. And Mr. Justice Jacobs went into all of that in great detail from paragraphs 135 to 170, and his conclusion was that there was no novus actus or break in the chain of causation, that there was no error of law by the tribunal in relation to causation. Again, paragraph 149, he says it's at best a question of mixed factor. He dismissed all of RTI's causation arguments. He did not give them permission to appeal, and that is that. And the answer to my Lord Justice Arnold's question to my learned friend yesterday, is it open to you to take that point in this court, is no. And it's not open to them to smuggle it back in and pretend that they're putting it in a different way, because that point was argued, and it was lost, and no permission to appeal was given, and that's that. Now, the only authority which is really cited in favour of this narrow construction is the At-Cor case, in which the Canadian Court of Appeal were prepared to read into a reasonable endeavours proviso some wording. The wording of the clause, my learned friend showed it to you, I won't ask you to look it up, to take it up again. The clause referred to causes by which the exercise of due diligence the affected party cannot overcome. The first instance, the judge has said, well, that refers to overcoming the causes, and what that means is overcoming basically the underlying event, which was a breakdown of compressors in the pipeline. And the claimant has said, well, that the problem could have been overcome by taking substitute gas, getting different gas, or something like that. And the judge said, well, that wouldn't have overcome the basic problem, which is the breakdown in the pipeline, and therefore it doesn't qualify. The Appeal Court of Alberta was prepared to read into the wording, quote unquote, the effect of, so that the clause would be triggered if the effect of the clause was overcome. And my learned friend relies upon that here. We don't know what principle of construction applied in Alberta in 1996. I would submit that it is very questionable whether you could make that interpolation under the principles of construction which apply in this jurisdiction today. But even if you could, it doesn't actually help my learned friends to read the effects of into the clause, because one of the effects of the event was that RTI couldn't pay in dollars. That had the knock-on effect of affecting the cargo operations. But again, switching to payment in euros wouldn't have overcome that. So it would not have overcome the effects. It would have overcome one effect. But that's not what the wording suggests, which is submitted to be written in. But my primary submission is you just can't get that wording into this very clearly written clause. It's plain what it means. And it means the same thing in A, B, C, and D. Now, I then come to RTI's authorities. My Lord, they amount to a miscellany of cases, none of which purport to endorse or support the proposition which RTI puts before you on the broad case, or even the narrow case, I think, really. The Act calls as close as you get on the narrow case. We dealt with them all in our skeleton argument at paragraphs 97 to 112, and precisely because they're not in point, and precisely because we dealt with them in writing, I wasn't keen to spend a lot of time dealing with them in detail. And I would just say a few things about a couple of them. Payson and Saunders. It's not about force majeure or even accepted perils clauses. It's not even about frustration. It's not about suspension. It's about breach and remedies and measure of damages. It's not about variation or non-contractual performance. The defendant in that case had repudiated by refusing to deliver on credit and demanding cash. And by that repudiation, the contract had been brought to an end. If it hadn't done, nobody would have been talking about mitigation, because you don't have to mitigate until you've got an accrued cause of action by terminating the contract. And so, if the claimant was going to make a mitigation purchase, it would necessarily, by definition, be a new contract. What Buyers' Counsel before Mr. Justice McCarty rightly called fresh contractual relations. Now, if the claimant went out and entered into fresh contractual relations with a third party, obviously it might be on different terms to the old contract. If they were able to find a contract which was on exactly the same terms as the old contract, then as Lord Justice Mail said yesterday, there wouldn't be any damages. It would be 100% mitigation. But the law of mitigation doesn't apply only when you can achieve a 100% mitigation. And the law of mitigation would require the buyer to accept different terms on a fresh contract from a third party, if that was a reasonable thing to do. And the only issue in Peizu was there some absolute rule of law that mitigation could never require the claimant to conclude a fresh contract on different terms with the contract? And the answer was no. There was no such rule of law. And the effect was that the claimant could not recover damages which would have been avoided if it had accepted the defendant's offer. It had nothing to do with non-contractual performance or varying the original contract. It's entirely about fresh contractual relations in the context of measure of damages. In this case, got nothing to do with damages. We're not claiming damages. We haven't exacerbated our damages by the way in which we behaved. Nothing to do with the issue. And the learned judge was absolutely right at paragraph 117 to say that there is no analogy at all. And with respect, contrary to footnote 4 of RTI's skeleton, the offshore construction textbook, when you look at it, doesn't actually say there is a parallel in the sense of suggesting that reasonable endeavours can extend to variation or non-contractual performance. In fact, if you read that text, it seems to be suggesting that a reasonable endeavours proviso does not require a contractor to perform other than in the manner and with the resources contemplated by the contract. If anything, when you actually read the text, rather than just the footnote reference, it appears to count against. BNS Contracts and Victor Green gets only a footnote reference now. Before Mr. Justice Jacobs, the proposition was, well, in that case, the Court of Appeal said that the contractor should have settled the strike by accepting from the employer an offered payment in advance. And what was said before Mr. Justice Jacobs, and I dare say by implication is still being said, is, oh, well, that payment in advance would have been a non-contractual payment. And therefore that shows that you can sometimes be required to accept a non-contractual performance. Now, the problem is, Mr. Justice Jacobs said, it's not in any meaningful sense a non-contractual payment. was a payment which the employer was not obliged to make. It was a voluntary payment. But there was no sense in which the contractor had a contractual right not to be offered a payment in advance. There was no sense in which the making of the payment in advance would have been a breach of contract. It's entirely different here. We have a contractual right to be paid in dollars. And switching the payment around would have been a breach. The Suez cases are all about frustration. In this case, that really is the simple point. The proposition which is put in my learned friend Skeleton at paragraph 65 is that those cases show that the closure of the Suez Canal did not frustrate a charter party, even when the charter party required the voyage to proceed through the Suez Canal. And they state that by cross-reference to Professor Peel at paragraph 4111. It is not right. Because if you look at the Eugenia in the authorities bundle at page 726 in the Court of Appeal, Lord Denning said, the fact that the charter party requires the owner to give notice on passing Suez, which is what these charters said, did not make it a term of the contract that the ship had to sail through Suez. Lord Justice Danckwerts, a couple of pages on, agrees with everything that Lord Denning says. The fact that you've got that reference to giving a signal when passing Suez shows that the parties contemplated at the time of contracting that the voyage would be via Suez. But Lord Denning says the obligation is to proceed by the customary route at the time of performance. And if that means you can't go through Suez because Suez is closed, then the obligation is to go round the long route. So they're not actually cases in which there was a contractual obligation to proceed in a particular way. But even assuming that that's right, the Professor Peel is right, and there was a contractual obligation to go through Suez. All you get from these cases is that the fact that a contract can't be performed strictly according to its terms does not necessarily mean that it will be frustrated. Which is unremarkable, because if it were otherwise, contracts would be being frustrated all the time. It will be commonplace. And it is trite in English law that frustration is not commonplace. It operates within narrow boundaries, and it's exceptional. Just as it's trite in English law that you can't terminate a contract just because the defendant breaches it. It's only if the breach goes the route of the contract. Termination is an extreme remedy. Reserved for extreme cases. There are other situations in which you may have to put up with bad performance and claim damages. But as Mr. Justice Jacobs said at paragraph 128, we're not concerned with anything to do with frustration here. We're concerned with the force majeure clause. The remedy is not termination of law, it's suspension. And as he also recognised at 127 to 128, the very reason that parties put force majeure clauses into their is to alter the rather complex and narrow and difficult position which applies at common law under the rules of frustration. If a force majeure clause was simply intended to reproduce in express terms the common law of frustration, then, coming to one of my Lord Justice Newey's points yesterday, the whole thing would be redundant from back to front. My learned friend cites Thames and Total for the proposition that the doctrine of frustration forms part of the legal backdrop to construction force majeure clauses. That may be right, but Mr. Justice Clark was quite explicit at paragraph 49(4), this is in tab 15, that you don't go around construing force majeure clauses on an assumption that they simply mirror the law. Again, if they did, there'd be no point. And you can see immediately looking at this clause that it doesn't mirror the law, precisely because the remedy is suspension and not termination. And the fact that this contract was coming towards an end and there was a possibility that the suspension would last until the expiry date, and therefore it was as good as termination, that's a fact-sensitive point which doesn't affect the actual construction. The construction has to apply in all circumstances. As a matter of construction, it is not seeking to reproduce the common law of frustration, and looking at the Suez cases does not help you to interpret it. It's It's meant to modify the common law registration. So by definition, you shouldn't be looking at the unmodified common law registration for guidance. And it is in my submission not right to say, as my learned friend says at paragraph 69, the Suez cases show that English law is reluctant to allow a party to quote-unquote down tools. What they show very specifically is that the English courts are reluctant to find that a contract has been terminated for frustration. But that is just a truism. The Transferven case, what you have there at tab 16 is a long and complicated New York Arbitration Award in a case governed by New York law, which gave rise to a host of issues. There is one page, tab 16, page 410, which is said to show that as a matter of US law, if an agreed manner of payment fails, the seller may have to offer and the buyer may have to accept a commercially substantial equivalent. We said in the skeleton argument, it's not even clear why that issue arose, because if you look at that page, the contractor's quibble was not about currency. The contractor's quibble was that the employer had chosen to pay at a spectacularly artificial and low exchange rate, with the result that the contractor suffered a huge exchange loss. And the contractor wasn't saying, I want you to pay me in the original currency, which was dollars rather than bolivars. What the contractor was saying is, I want you to pay me at an appropriate exchange rate. But never mind that. To the extent that the case does, and the other American authorities do bear out the proposition which is put forward by my learned friend, they do so because that's what the United States Uniform Commercial Code says. And if that's what the United States Uniform Commercial Code says, it's hardly surprising to find authorities in which that's applied. And the suggestion appears to be that there's no reason why the court couldn't read this contract as though it said exactly what the United States Uniform Commercial Code says. But there is a reason why the court can't do that, and the reason is it's not what it says. And there's no process of construction by which you can make it say it. Then the final one is the Libyan Arab Foreign Bank case. This one isn't actually referred to in our skeleton argument because this came into my learned friend's skeleton by an amendment. Now, footnote 11 sets out a fairly chunky quote from Lord Justice, Mr. Justice Stoughton. When you read it, you can see that it is simply a fairly uncontroversial application of the Brightman principle. It postulates a situation in which you have an obligation to pay either in dollars or in pounds. That is your obligation, to pay in dollars or pounds. Just as in Brightman, your obligation is to ship goods or barley or rye. And what Mr. Justice Stoughton says is if you want to pay in dollars but you find you can't get them, then you've got to pay in pounds. Now, that, as I say, that is simply an uncontroversial application of the Brightman principle. The Brightman principle has no application here. The obligation is to pay in dollars. That's it. There was a substantial argument before Mr. Justice Jacobs about whether there might be some right to pay in euros. Mr. Justice Jacobs said that there wasn't. He said the tribunal were right to hold that it's a dollar contract and that's all. And you do not give permission to appeal on that. So that's that. And so, but also all of those reasons of principle and authority, which are substantially those set out by Mr. Justice Jacobs' judgment, we respectfully invite you to dismiss the appeal. And we do submit that it's not surprising, as RTI say, that if we had a contractual right to payment in dollars, it was not incumbent upon us to give it up in order to disable ourselves from relying on an FM defence. And again, it sometimes sounds trite, but that's the nature of a right, given to a party to exercise as it sees fit in its own interest. It is not likely to be taken away. There is nothing in this contract to suggest that it was taken away. And my Lord, I think I timed it not badly, but that is all I wish to say, subject to your lordships.
Thank you very much, Mr. Eaton. Ms. Silver-Appellant.
Thank you. My Lords, I will endeavour to conclude by lunchtime. Can I start by stating that RTI maintains all of the submissions previously made, and I will not seek to repeat what I have already submitted. In relation to the points of distinction between our case and the Bullman case and the Vancouver strikes cases, we maintain those points of difference that we went through in our initial submissions. To that list, we should now add a further point of distinction with Bullman, which is the one my Lord Justice Mayles helpfully drew attention to, which is on the facts in Bullman. It was a matter of importance to the charterers that the vessel should go to Regent's Canal. That is the finding that appears on page 4 of tab 1 in the first complete paragraph. That is to be contrasted with the present case, where what is offered in terms of payment is the commercial equivalent of US dollars. It is not at all on a par with any of the facts in Bullman. If I could start then with a general topic about approach to interpretation and implication of terms. My learned friend's submissions on this were at times contradictory. Mur have been at pains to suggest that the principles applicable to construction in Wood and Capita and Arnold and Britton and Marks and Spencer are unlikely to assist. However, they go on to place great weight upon the Gilbert-Ash principle, also a principle of construction, which they maintained was relevant. On the facts of our case, reliance on Gilbert-Ash is wholly inapposite. There is no deprivation of any valuable right which Mur possessed. As the tribunal has held, there was no detriment to Mur in accepting euros on the terms which RTI had offered. And if there was a breach of contract, it would have sounded only in nominal damages, because there was simply no loss to Mur in accepting the euros on the terms offered. Now, if Gilbert-Ash is to be considered at all, it should raise concerns about the parties being deprived of valuable commercial rights through Mur's attempt to rely upon force majeure to suspend performance of the COA based upon a marginal non-conformity with the currency of payment. And as my Lord Justice Mayles observed, I believe yesterday, they are receiving dollars. It is simply the mode of transmission of those dollars which is objected to. And that should be a matter of complete irrelevance to Mur. My learned friend's reliance on analogies with Bullman and Vancouver strikes is an attempt to avoid focusing on the real construction of Clause 36. And that is what they persuaded the learned judge to do. When you look at Clause 36 analytically, there is no warrant for any exclusion from Clause 36(d)(3) of acceptance of offers of non-contractual performance, and certainly no exclusion of offers to pay in a commercially equivalent currency of euros. Now, my learned friend, in his skeleton at paragraph 16 and orally, referred to authorities which he said supported implied restrictions qualifying the operation of a force majeure clause or an exclusion clause. In our respectful submission, that does not help, and that's again why looking at Bullman and the Vancouver strikes cases don't help, because there is no substitute for construing the actual terms of the express clause that has been agreed between the parties, and in particular the specially introduced clause 36.3d. And my lords, as learned editors of Scrutton say at tab 37 in one of my learned friends' authorities, if you can just get that out. This is under the heading Effect of Accepted Perils in the Contract of Affreightment. The last sentence says, In each case, the precise wording of the exception relied upon will be important, and citation of cases involving different wording will be of limited assistance. So we would advocate strongly that you approach matters in a conventional manner and not rationalise by analogies which in fact are not truly existent with either Bullman or Vancouver strikes. I'd now like to turn to an introductory point, which is the requirement for an event to be beyond a party's control and the requirement for it to be incapable of being overcome by reasonable endeavours. And to make the point that those limbs have distinct roles to play. We might wish to have clause 36 open, and it's in the award, most conveniently in large print at tab 7 of the core bundle, starting at page 121. Now, the principled explanation for there being a difference between an event being beyond a party's control and it being incapable of being overcome by reasonable endeavours excuse me, is that the former is pre-event, and the inquiry is, could the party have stopped the event from happening? The latter is post-event, and the inquiry is, could the party have mitigated its effects?
Sorry, why is A restricted to pre-event situations? Why could it not be during?
Well, the implicit requirement is that the event or state of affairs, which is how force majeure event is defined, has to be outside the immediate control of the party. And if it is within the control of the party, then it won't qualify. But if the...
This is all expressed in the present tense. I mean, I appreciate one shouldn't give too much weight to tenses, but it doesn't say it was outside the immediate control of the party.
The point of distinction, my lord, that I'm seeking to make is that you're looking at an event which arises, or a state of affairs which arises, which is outside the control of the party, which is the logically prior step. And you're then looking at what can be done by way of reasonable endeavours post that event and state of affairs arising to mitigate its effect. So that's what I'm endeavouring to draw the distinction between. And there is a distinction for the reasons given, both as a matter of logic and also supported by the academic texts. In favour of that distinction is Chitty at tab, page 712 of the authorities bundles, at tab 26. We turn to 712. Under the heading General Propositions. The learned authors there list requirements, although they stress...
Can you give me the paragraph again, please?
Yes, 26066.
Thank you.
And they say, in such a case, the court is likely to conclude that the type of event will fall within the scope of the clause is an event that was, 1, beyond reasonable control of the parties, and so wouldn't include an event caused by negligent submission or default of one of the contracting parties, 2, causative of non-performance, and 3, couldn't have been overcome or avoided by the taking of reasonable steps. So it is a separate consideration. Also, Professor Peel at tab 34, paragraph 12045 at page 780. If we could pick it up at 12045 by the first hole punch, where he states as follows: in practice, the distinction which appears to be drawn, if intended, may be illusory. This is referring to the Cedral Garner case and the obligation to use reasonable endeavours and linking it to beyond
I'm sorry,
control.
Mr. Ratnam, where are you?
I'm
Which page?
12045, page 780.
Ah.
Sorry.
My fault. Thank you.
And picking it up after the reference to footnote 280, Professor Peel states, in practice, the distinction which appears to be drawn if intended may be illusory. An event only amounts to force majeure if there is at least some link between it and a party's failure to perform, for example, an event preventing fulfilment. And if through the taking of reasonable steps performance is still possible, there is no force majeure. In some cases, however, it may be that the event itself could have been avoided by taking reasonable steps. See, for example, the example of strikes referred to in the preceding paragraph, while in others the event could not reasonably have been avoided, but its effect on the performance of the contract could have been. So there, the distinction that I've sought to make is recognised.
Well, no, it's not, because it's completely against you on a temporal distinction. It supports you on the more general point, which is you say these are different requirements. But if you can avoid it in advance by taking temporal steps, then that destroys your temporal distinction.
Well, the temporal distinction is not fundamental to my argument. We are simply seeking to show that they are different requirements and that each has to be satisfied. The learned judge in paragraph 151 of his judgment, and I'll just pick that up at tab 5, he concludes the relevant matters described in the award come within those wide words in section 36.3c. They were all very obviously outside the control of the owner, so there was no error of law in the tribunal concluding that clause 36.3a was required. So this is was satisfied. So again, this is showing the separate nature of the particular limbs of the clause.
Well,
Now,
to be sure, I don't. Once one gets away from the suggested temporal distinction, I don't have any difficulty with your suggestion that these are separate requirements. After all, apart from everything else, it's different words, different parts of the clause. One starts with the assumption this is not surplusage. But how is that relevant?
well, it's relevant on the facts of this case, and that it's relevant when considering the types of force majeure events and states of affairs that are likely to arise in practice. One is likely to arise antecedent to the other, and that's the only point that I'm seeking to make. Can I turn to a different, well, in fact, it's my Lord Justice Newey's observation yesterday, that if you have both 36.3a, which is the outside the immediate control of the party giving the FM notice requirement, and you also have an express requirement, it cannot be overcome by reasonable endeavours from the party affected, then you should assume and presume that each has independent importance. And second, the fact that you have a reasonable endeavours requirement here was specifically added in the recap. And of course one has the general presumption that where you have got parties specifically negotiating a provision, that is deemed to be of more importance in determining what the overall construction ought to be, and that is given preeminence when construing it together with the typed parts of the clause. Now I'd like to turn, if I may, to the question of what it refers to in sublimbs A, B, C and D. And if I had given the impression yesterday that they meant something different in each of the clauses, I did not intend to do that. And a force majeure event, as defined in 36.3, is an event or state of affairs which meets all of the following criteria. So under 36.3a, it must be an event or state of affairs outside the immediate control of the party giving the notice. Under B, it must be an event or state of affairs that prevents or delays loading or discharge. Under C, it must be an event or state of affairs that's generated by one of a number of those specified causes. And then under D, it has to be an event or state of affairs which cannot be overcome by reasonable endeavours from the party affected, which in this case is Mur, because they are the party that served the force majeure notice. Now, my learned friend made some submissions yesterday and this morning to the effect that it may be the case that RTI could have served a notice, and it may be that it wasn't in its interest to do so. My lords, the factual background makes it very clear, and indeed the findings in the judgment make it very clear, that it was Mur that shut down the possibility of further performance of the COA by refusing the possibility of US dollar payments, and they used that as the basis for refusing to nominate any further vessels for loading. And this required RTI to go into the market and mitigate those lost nominations, and that formed part of their damages claim. So it was never going to be the case that RTI were going to be content with suspending performance. They were offering euros in order to meet Mur's shutdown of the possibility of a payment in US dollars.
To be sure, everything you've just said is undoubtedly correct, but do you dispute the point that I understood Mr. Eaton to be making, namely that it's not relevant for this court to ask itself what the position might have been had RTI been the party seeking to invoke the FM clause, because RTI didn't invoke the FM clause, and therefore wondering what might have happened in that scenario is nothing to the point.
Well, my lord, I'm only dealing with it because my learned friend raised it and it appeared to be of relevance in the course of
Well, it was in answer to the questions from the court.
Yes, it was. We submit that the factual background is important. It is important when considering whether or not there was a refusal by RTI to perform in accordance with the contract. There was no refusal by RTI to perform in accordance with the contract. Once the possibility of sending US dollars had been shut down, it became impossible to remit US dollars. And Mur were maintaining, as is recorded in the judgment at paragraph 28 in their force majeure notice, that it was unlawful to continue to perform the COA. Now, in that contention, they were proved wrong by the expert evidence and by the findings of the tribunal.
Well, again, to be sure, but I don't understand you to be disputing that, one, RTI didn't invoke the FM clause, and two, it's irrelevant for us to inquire what would have happened if they had.
My lords, unless there is any particular issue that turns on it, which I inferred that my lords may think there was because of the questions yesterday and my learned friend's development of the factual point this morning, I'm content to leave it there. But we do say that where one party cuts off the possibility of performance strictly in accordance with the four corners of the contract, it lies ill in their mouth to then say that the event cannot be overcome by reasonable endeavours from the party affected, because they could, as found as a fact by the tribunal, easily have accepted the offer of payment in euros with no detriment to them.
What do you say that it is? You've accepted that it means the same in each of
Yes.
A to D. It is an event or state of affairs. There has been some suggestion that it may be the restriction on monetary transfers, but actually C makes clear that it has to be something which is caused by a restriction on monetary transfer, so that would seem to say that it can't be the restriction on monetary transfers itself. And it seems to me that if we are to consider whether something can or cannot be overcome, we've got to know what that something is.
Yes.
To address that question. So what do you say is the event or state of affairs which we should be addressing
Yes.
our minds?
My lord, on a fair reading of the award, the tribunal appears to have found that Mur were not willing to continue loading and discharge of cargoes without an assurance of payment. And the assurance of payment in dollars was going to be affected by the restriction on monetary transfers, which was the conclusion of the experts, the finding critically in paragraph 45, which refer to the hold-up or potential delay of transmission of US dollars reaching Mur's account. So this, going back to paragraph 45, page 130 of tab 7, the experts were agreed that in the event RTI was required between the 6th of April and the 23rd of April 2018 to make any US dollar payments to Mur that pass through an intermediary bank in the US, which is highly likely, it is highly probable that the US intermediary bank would have initially stopped the transfer on the basis of RTI's status as a block party until the bank could investigate whether the transaction complied with US sanctions requirements. So that is the event within and state of affairs.
Just to see if I've captured what you've said there, you say the event is the high probability of a delay in transmission of US dollars. Is that your case?
Yes, that appears to be what the tribunal has found and what the case has proceeded to assume is the relevant force majeure event or state of affairs, which prevents or delays loading.
I think saying the same thing. So the event, you say, is effectively the friction in the system.
Yes.
And the friction in the system, on the tribunal's view, prevented or delayed the loading of the cargo.
Yes. On a fair reading of the award, that appears to be what they have concluded. Now, 36.3d requires that event or state of affairs not to be capable of being overcome by reasonable endeavours from the party affected, i.e. Mur. Now, what 36.3d contemplates is that reasonable endeavours can render the putative qualifying event or state of affairs within C a non-force majeure event or state of affairs. The party affected cannot stop the event being an event or state of affairs, but it can potentially stop it being a qualifying force majeure event or state of affairs. And how that is to be achieved is driven by what makes it a force majeure event in the first place, i.e. it has to comply with limbs A, B and C. So, drawing the threads together, if some action gives Mur control of the event or state of affairs, or removes the impediment to cargo operations, or, talking hypothetically, affects the high-level event itself, or the high-level state of affairs, so as to remove it from 36.3c, then the force majeure event will have been overcome. Now, the thing that has to be overcome is not an inability to perform the contract, it is the application of the conditions in 36.3a, b and c. There's nothing in clause 36 that draws a distinction between situations in which the endeavours are acts that a party has a right not to perform, an option whether to perform, or no right to perform until offered the opportunity. There can be many things that a party has an unfettered right to do or not to do, but that doesn't mean that the party can establish force majeure if that party fails to do them in a time of contractual crisis. Now, in many cases, there won't be a consensus on these matters, but the pragmatic solution to an impasse may be clear. And this ties in, I believe, with my Lord Justice Newey's point from yesterday, that Mur was effectively saying that contractual performance in US dollars was not good enough. For clause 36's purposes, we say that's really neither here nor there, and that whatever the impediment to loading or discharge was, the force majeure event could be overcome by dealing with that impediment, be it a delay in US payments or illegality of US payments. Now, the degree of non-contractual performance and the level of prejudice go to reasonableness, but we here have a finding of fact by the tribunal in paragraph 50 that there was no detriment to Mur, and the tribunal found also as a matter of fact that being reasonable they ought to have accepted euros. And we submit that that's the correct way to understand what the judge was in fact saying in section 114 of his judgment, where he accepts my learned friend's submission that 36.3d isn't to be construed as focusing only on a single aspect of the COA, namely loading and discharging. The clause requires that the it referred to cannot be overcome by reasonable endeavours from the party affected. The word it is used at the outset of A, B and C and D, and it refers to the force majeure event or state of affairs as a whole. It isn't confined simply to loading or discharging.
Sorry, you gave a judgment reference.
Yes,
there.
it's actually paragraph 114, core bundle, page 86, my lord. And Mur, in fact, endorsed that view in their skeleton of paragraph 120. Now, the word overcome must refer and relate to an event or state of affairs that stops force majeure operating. And on the facts of this case, acceptance by Mur of euros on the terms offered by RTI did stop force majeure from operating. There was no longer any force majeure suspension after they agreed to resume nominations and accept euros. That's paragraph 50. And the damages claim was limited to the period in which they refused to nominate, based upon their contention that it was unlawful to carry out the COA. Now, that analysis, I would respectfully submit, shows that there is absolutely no reason to reject within the scope of reasonable endeavours conduct which, as a matter of fact, has the effect of negating a force majeure event and state of affairs within A, B and C, and which, as a matter of fact, has been found by the Tribunal of Fact to be reasonable. It stopped the force majeure event and state of affairs from operating, and that is what D is directed to. A point that I would like to go on to make is that there should be no reason for the court to feel reluctant to deny ability to rely upon a force majeure clause by a party who unreasonably refuses to accept non-contractual performance, and tying it to the facts of this case, remitting euros so that dollars can hit its account rather than remitting dollars with the risk of those being delayed. Now, in the Suez cases, which my learned friend has dealt with quite briefly, yes, they were frustration cases, and the impediment was overcome by going by a non-contractual route, even in cases where,
But it wasn't a non-contractual route, as Mr. Eaton just pointed out. The contract didn't require passage through Suez.
There were others that did, my lord. If you go to what Professor Peel's discussion is in connection with the Suez cases, I think it's just the
If you
Eugenia.
look at Lord Justice Denning, he says in terms it didn't require, Lord Denning, Master of the Rolls, I should say, apologies to him, he says in terms it didn't require passage via Suez.
But there are other cases where it is clear that it did require passage by Suez. If we go back to Professor Peel at the end, well, in paragraph 4.111 at tab 32, on page 757 of your bundle, there's a section that deals with where the Suez route is expressly specified. And the learned professor discusses those cases, including a case called American Trading and Shell. And then he concludes in the final paragraph of 4111, thus even the failure of an expressly or impliedly stipulated method of performance will not discharge a contract if that method is not of fundamental importance, unless the parties make it clear that they intend the stipulated method to be exclusive. So, given the time, I'm not going to go into the detail of those cases, but I would invite the court to study that section and to look at the underlying cases that are in the bundle, because they do not all rely upon an implied contractual route. There is also the express contractual route. And that is the reason for the rubric preceding that discussion in 4111 of Professor Peel's work. So in the Suez cases, in the frustration context, the impediment was overcome by going by a non-contractual route. And there are important parallels to be drawn here when considering whether there is a bright line requiring continued performance of the contract in accordance with all its terms to avoid discharge or suspension. Asking the question rhetorically, how can payment in euros hitting Mur's account in dollars, with all expenses associated with that transmission being borne by RTI, and no downside to Mur as a finding of fact, not overcome the relevant impediment in a force majeure context? It enabled Mur to receive dollars in its bank account through transmission of euros. Now, the Suez example that we've given in our skeleton at paragraph 70 is, in my respectful submission, a useful example. Suppose that this, I'm just reading that section now to avoid you turning it up, but it's in paragraph 70. Suppose the COA had stipulated a route via Suez, but that the Suez Canal was closed for the foreseeable future by government interference. On the face of it, the discharge of cargo would be prevented, but the Suez cases suggest that force majeure would be avoided if there was a commercially reasonable and available alternative route, i.e. one that ought to be acceptable to a party exercising reasonable endeavours to overcome the putative force majeure event. And that's even if the COA stipulates a contractual route by Suez. Now, were the position not as we suggest, then it would be wholly uncommercial, and clause 36 would, as Mur have you believe, entitle them to bring about a perpetual suspension of the COA, where the law of frustration would offer a more pragmatic solution. Now, that seems entirely the wrong way round. Now, the fact that it was an entirely realistic alternative, as the tribunal have found, to pay in euros, with Mur receiving them in dollars in their account in Amsterdam, is confirmed by the fact that that's what they did when they decided to resume nominations. Now, they suspended based upon an incorrect assertion in the force majeure notice, both of illegality in continued performance of the COA and illegality in payment of dollars. And they didn't succeed on either of those points at the arbitration. We submit there's no reason for this court to be hesitant about treating reasonable endeavours as a pure question of fact. So, as my Lord Justice Newey put to me quite early on yesterday, would it matter if you had the 1st of January as your contractual date of performance, if you could only perform by the 2nd of January or the 10th? It is all a question of fact, and the court shouldn't be reluctant to accept that this is something that the tribunal, in particular on the facts of our case, were well equipped to decide. It doesn't cause uncertainty any more than a mitigation inquiry causes uncertainty, or any more than ambiguous legal rights in a contract create uncertainty. Here, Mur, by not being prepared to accept dollars and making it clear in their force majeure notice that they thought it was illegal to be paid in dollars, made it inevitable that this contract could not be performed unless and until they were prepared to accept euros as a way round. And it's perfectly understandable that the tribunal in these circumstances found that it would have been reasonable for them to behave in that way and thereby overcome the force majeure event and state of affairs that it created, which will obviously include its effects. And that perfectly understandable finding of fact should cause no the market. What Mur eventually did in April was to resume nominations on the basis of being paid in euros. So this is a wholly technical case being maintained by Mur in order to avoid liability in damages for that period when they did not nominate, based upon a misunderstanding of the sanctions regime, and where RTI went out and mitigated through fixing other ships. We do submit that mitigation cases do provide a powerful analogy for the reasons that we previously gave, and they do support our submission that Mur has to consider offers of non-contractual performance, particularly where they don't result in any detriment. In terms of the point on causation, my learned friend suggests that I can't make any arguments about causation, but the learned judge, in giving permission to appeal on 36.3d, made it quite clear that all the arguments that had been canvassed in relation to causation on 36.3d were in play, and as my learned friend's own skeleton accepts at paragraph 19, reasonable endeavours provisos are a logical corollary of the requirement for causation. So one cannot exclude causation considerations from the debate. My Lords, the importance of the issues in this case will remain whichever party is ultimately successful. My learned friend made the point that it will have significant effects beyond the parties to this case if my clients succeed. But if his clients succeed, the same result follows.
Was there a draft grounds of appeal before the judge at the consequentials hearing when he dealt with permission
No,
in the usual way?
There wasn't, my Lord. We had a hearing, a remote hearing, which involved the hand down of the judgment and an oral application by my clients for permission to appeal. And we sought permission to rerun the same point upon which Mur had been given itself permission to appeal by Mr. Justice
And that's
Calvin.
exactly what the judge gave you in paragraph
Yes.
6 of his order at page 56. The Beaumont
Yes.
says you're granted permission to appeal on the Court
Yes.
of Appeal. The question of law raised in paragraph 6 of the claim form.
Yes, my Lord. So that's exactly what we sought and what he gave.
Yeah.
So the point remains that it's a point of significance, of general importance, whichever party succeeds. And for all of the reasons that we have submitted, we urge you to allow this appeal, because that will send the correct message about the correct way to interpret force majeure clauses and will not introduce an artificial straitjacket to what can and cannot amount to reasonable endeavours, which is first and foremost a factual question for the trier of fact. My Lords, can I just take some instructions behind that? My Lords, one remaining point is whether you would like a transcript. We understand that matters are recorded, and it may be that it would assist you if the parties were to provide you with a written transcript, if you would like.
One thing that we now have, of course, is actually a video archive.
Yes.
So, speaking for myself, I find that if there's a point in my notes on which I'm uncertain, I can look at the recording and see exactly what was said. But let me see if my brethren take a different view on the desirability of a transcript.
It's not one where they've actually got one coming anyway.
It is the case, isn't it, that there isn't a pre-existing transcript? It would be.
I don't believe
specially
so. We
ordered.
need to ask for a transcript to be produced from the recording.
In which case, had there been a transcript in existence, we would certainly have liked it, but we don't think it appropriate to ask for one specially to be prepared. In which case, thank you very much. Well, as you would appreciate, we're not going to give judgment here and now. Thank you both, and thank you to those behind you for very interesting and thought-provoking submissions. In the normal way, as it now is, we would expect judgment to be handed down remotely without any attendance in person, but even if there were to be a hand down in court, there would be no obligation on anyone to attend. Again, in the normal way, you will be supplied in advance with a draft of the judgment for you to provide us with typographical and similar corrections, but not to re-argue the case. And we would be grateful if, in advance of the hand down, you would seek to agree a consequential order. If there are any points on which you disagree, can you please provide brief written submissions, and we would expect to deal with the points in the order that we make. In terms of the distribution of the draft judgment, I suspect the Bar is probably all too well aware of the Counsel General for Wales case, in which warnings were given as to restricting the distribution of judgments. As I understand it, in this case, the parties have already provided a representation list indicating email addresses to which the draft should be sent. And I'm assuming that there are no adjustments to that. All I would emphasise is the need, as was stressed by the Court of Appeal, for strict compliance with the confidentiality obligations. But with further thanks to you all for your submissions, we'll leave it there.
Thank you very much, members.